E nā mana whenua o te wanganui a Tāra, tēnā koutou. E nā tūpuna, tēnā koutou. E nā whetu o te apāranga, tēnā koutou. Tēnā koutou, tēnā koutou, tēnā koutou katoa. I'm really worried now because I'm following you, Damon, and I'm going to talk about something that's a bit Eurocentric, but it happens in every culture. So I'll talk about a little bit of it. And of course, it's a bigger question. So lawyers work with layers of different and sometimes very specialised texts, legislation, judge-made law, treaties, and my scholarship attempts to frame this legal detail within larger movements of legal and political thought, and to treat law as a variety of political thought. And today I thought I would introduce briefly my new Marsden-funded project. I haven't discovered anything yet, but I'm still in that process, to demonstrate something of my method and of the range of sources that I'm beginning to use. I grew up very humbly in Wanganui. My parents had never heard of the Royal Society, although my mother quite liked the Queen. Their favourite television program was Yes, Minister. It featured the supercilious and wily Sir Humphrey Appleby, whose withering acclamation, "Yes, Minister," usually indicated that the minister's programs and policies had once again been trounced and supplanted by Sir Humphrey's own. This popular image of the unresponsive and resistant public servant gained currency just as fundamental reforms were being made to the public service around Westminster-style constitutions to make public servants more responsive. Based on economic models of agency, the public servant was freshly conceived as the delegate or the agent of the minister, apparently without any independent mind of her own. The new economic model seemed to owe something to Machiavelli, although Machiavelli was never mentioned, who thought that the secret to good counsel was to align the private interests of the counsellor with that of the prince. In its modern guise, this meant key performance indicators, bonuses, less by way of security of tenure, and so on. Nevertheless, something of an older humanistic view of counsel survived. The humanists thought that the pursuit of private interests by politicians and their counsellors is the definition of tyranny. That a good counsellor should give honest and often unpalatable advice in order to sometimes change the prince's mind. That he should educate the prince, who after all may be sovereign and omnipotent, but even so was never omniscient. That it is only good counsel that makes sovereignty palatable. And that good counsel mediates and improves relationships between the sovereign and the citizen. And today, these humanistic ideas survive in the legally unenforceable constitutional conventions and public service codes of ethics, which sit loosely alongside the hard incentives of the more Machiavellian new public management. The way these values are expressed vary, sometimes significantly. And in New Zealand, for example, the Constitutional Convention is that civil servants should give advice freely and frankly. In Australia, it's freely and without fear. Now, the earliest usage I've found is in Hobie's 1561 English translation of Castiglione's The Book of the Courtier. But this idea of frank counsel or parrhesia goes back much further to Athenian democracy. So this is a really old constitutional idea across different cultures. In an age of populist post-truth politics, and I did have Trump in mind when I thought of this project, climate change and pandemics, it's more important than ever to get the balance right between a responsive public servant and one who educates, presents evidence, engages in long-term thinking, and sometimes even resists ministers. And my question is how the law and legal doctrines and institutions especially the judge-made law of judicial review of administrative action, can better support the independent advice-giving function and how it can do that consistently with modern democracy. In the process, I hope to better theorise the practice and principles of modern administrative law. So it's easy to see why the education of princes and conceiving of the advisor's role as one of equal friend rather than flatterer, that's Plutarch, was central to political and constitutional discourse at a time when absolute monarchs ruled by hereditary title. The monarch was sovereign and unaccountable except to God. The people could not hold the monarch to account, only his counsellors. The prince did not have the benefit of collective judgment, only his favourites. Good counsel at that time was seen as a crucial check on tyranny. But at least so far as some political theorists were concerned, these insights applied equally to democracy. Indeed, classical democracy was as much, if not more, prone to flatterers and the effects of misleading or bad counsel than monarchy. Who's being flattered? It's the people who are being flattered. The infallibility of the sovereign demos, the idea that the sovereign people could not be wrong, was a reason to hold its advisors and those who initiated bad law to account for bad and wrong advice. And under the judicial doctrines of the time, they paid compensation for that. Modern representative democracy in a constitutional monarchy is, of course, very different to that of Athens. Sovereignty may, in fact, if not in name, have passed to the people, but the people's direct sovereignty is only expressed sporadically when choosing its representatives. And those representatives, in turn, are not merely delegates of the people, but are also trustees for the people. The public service, in its turn, plays both delegate and trustee roles on behalf of the sovereign demos, though certain officials, I would argue, such as the Solicitor General and the Director General of Health, may be much more trustees than delegates. As in ancient Athens, judicial doctrines which ensure accurate evidence is put before decision makers, that the long-term public interest is taken into account and so on, serve democracy rather than constraining it. Or alternatively, if one subscribes to the view that sovereignty and government are separate things, there is no reason to require or respect bureaucratic administration to be democratic at all, or to be representative in the same ways in which the legislature is. On that view, democracy simply sets the parts in motion and the sovereign sleeps until it is woken again. These are big questions of constitutional and democratic theory, and part of the project is to tease out the relationship between these big ideas and the more detailed doctrines and concepts of the common law throughout the Commonwealth. For reasons of history and accident, the common law treats both the elected officials, ministers, and unelected officials, public servants, as servants of the Queen. There she is again. Public servants in Westminster systems do not enjoy an independent constitutional identity of their own, unlike in civilian systems. And I think we could actually improve the law if we were to conceive of them as having independent constitutional identity. Accordingly, when judges talk about deferring to elected ministers, they don't usually differentiate between the elected and unelected parts of executive power, and usually for unexamined democracy-respecting reasons. If we were to differentiate more clearly between ministers and civil servants, the courts could come to view one of the court's functions as supporting an independent, advice, evidence-based civil service, speaking truth to power to elected representatives. And I think this would lead to a more principled and robust view about when it's proper to defer to political judgments. Well, of course, no one watches Yes Minister anymore, not even in Wanganui. It's Thomas Cromwell, counsellor to Henry VIII, who's more familiar in our popular culture. And that's fitting for our time. Things did not work out so well for Thomas Cromwell. Speaking truth to power then, as now, can be a dangerous business. Ngā mihi nui.